SJC-11586, Commonwealth v. Joshua Fernandes.
Okay, good afternoon, council, and I'll just remind people that pursuant to the SJC longstanding tradition, the single justices of this month and last month will not be sitting on these cases. Ms. Scapicchio, we'll start with you.
Sorry. Good morning, Your Honors. Rosemary Curran on behalf of Joshua Fernandes. May it please the court. Today, I'm here to argue on behalf of Mr. Fernandes 4 issues that I hope to cover in my argument. The first is that the jury selection in this case violated Joshua's 6th Amendment right and Article 12 rights to both due process and equal protection because of the systematic exclusion of everyone under 24 and most people under 30.
Counsel, on this point, you don't address, we decided this issue in Lopes. So if you're gonna do, and we may be wrong in Lopes, but you got to argue why Lopes is wrong. You can't just raise the exact same arguments that you raised in Lopes.
Well, I didn't raise the arguments in Lopes, and in addition, I don't think it was the exact same arguments. With all due respect, Your Honor, I think Lopes argued
different.
Well, I think Lopes argued that the challenges that the Commonwealth made resulted in a source type issue where people of color were excluded more appropriately than others. So
that's the second part of source. Second right. Part of Lopes. The first part of Lopes is exactly on point. You look at the issue. Yeah, I mean, you got to distinguish it, or you're wasting our time.
Right. Well, I'm not looking to waste anyone's time, Your Honor. What I'm doing is I argue it under both the equal protection and the due process clause, which was not argued by Mr. Lopes. And under the due process clause, what I'm asking this court to find, without having to exactly include age as a protected class, under the due process clause, find that the systematic exclusion of people under 30 from the jury pool in this case, which was the largest section of the population of the jury pool, resulted in Joshua not getting a fair cross-section of his community, and that's what violated his due process rights. That's a different argument in my mind from the argument that was raised by Mr. Lopes, and that's why I think the argument needs some attention here. And with respect to that argument, if I could just get into it a little deeper, in this case, the Commonwealth excluded all of the jurors under 25 and most of the jurors under 30. If you put those two categories together, it comes out to be about 81% of the jury pool that was excluded systematically by the Commonwealth when these jurors were already cleared for jury duty by the legislature. So what the Commonwealth does in exercising these challenges is it essentially tells the legislature that their regulation that everyone 18 and over is qualified for jury duty is wrong. And the Commonwealth already said in Mattis, when it argued before you, that you can't change the legislature by something that you do. And that's exactly what the result of the Commonwealth's actions in this case is. They're looking to, even though these jurors were cleared by the legislature and said that they were qualified to serve, they came up with this reason that young jurors can't make up their mind between which classes to take, and therefore, if they can't decide classes, then they shouldn't be able to decide guilt or innocence. There is no scientific, there's no scientific data to support that position, and the result of that position is what affected Joshua at trial. The result of the Commonwealth's position it struck every single solitary juror under 24 and struck most jurors under 30. And if under Soares, what this court said is that the jury of your peers equals a fair cross-section, then I think under Soares and all of the federal cases that I cited in my brief, clearly what the Commonwealth is doing here is preventing Joshua from ever getting a fair cross-section of the community under the due process clause, and that's unfair. So if you don't want to look at it under the equal protection clause, if you want to say that this issue is foreclosed because of Lopes under the equal protection clause, then I'm asking that you look at it under the due process clause, and you find in this case that because there was this systematic exclusion and because the Commonwealth was clear that it was a systematic exclusion, that was their goal, that they wanted to exclude all people of this age. And my issue with that is, what if next time they want to exclude all people who are gay or lesbian? Is that going to be okay with the court? Because it can't be.
It's a totally different thing. It's a protected class. I really do encourage you to maybe get to some of your new issues, but that's up to you. It's your 20 minutes, you know.
Well, I appreciate that, Your Honors, but I think this is an important issue. I don't think it was decided by Lopes. I understand that you do, but I'm hoping that you'll take a look at it under the due process clause and understand my argument is that the
In all
systematic.
the cases cited in Lopes, all those federal circuit court cases, do any of them draw the distinction you're drawing here?
On the due process claim?
Because this has been rejected. This argument has been rejected by every single circuit court of appeals. Do they distinguish your argument and say, well, we haven't decided this, but we've decided that?
I believe they're decided, Your Honor, under the Equal Protection Clause.
Which cases do make the distinction you want us to make? Any of those?
I don't believe that they do, Judge. I do not believe that they make the distinction that we're looking for this court to make here. And I think that it's the court has done it before. You've done it in OB when you recognized religion as a reason not to exclude jurors. The headscarf, the juror with the headscarf, that was OB. And I would suggest that if the court does that for religion, it can also do it for age. There's plenty of data in my brief about why age should be a protected class. And I asked the court to look at it and to evaluate it and to not be foreclosed by Lopes, because even though Lopes has decided, Mr. Fernandes has an absolute right to bring his cases in front of the court and has an absolute right to be able to argue and litigate the cases in the way that he sees fit. And that's why we're arguing it as both an equal protection and a due process claim. The next issue that I'd like to bring to the court's attention is the issue of the denial of the expert witness. In this case, we were looking to hire or to call Dr. Kincher as an expert witness relative to the mental condition for first-degree murder.
How do you distinguish Brown and Okoro? Because in both of those cases, we required the expert to have some testimony directed at the person, not just the age itself.
Well, I would say with respect to whether or not it's okay to have the people testify or the experts testify, that's exactly what this court is going to decide in Madison Robinson. In both the Madison Robinson case that Robinson will be up in the SJC soon, and Madison was just remanded. It was never about whether or not they evaluated Mattis and determined Mattis had some condition that the jury should know about. This is whether or not the issue of adolescent brain, the issue of whether or not this should be a factor that the jury gets to hear, especially in light of the fact that in this case, the Commonwealth was arguing that a 16-year-old had the capacity of an adult. And what we were trying to do is hire an expert to tell the jury that, in many cases, generally,
okay. Let me read you a sentence from Okoro. So Okoro, the same expert, Kinshiraf, I'm mispronouncing his name. This information was beyond the jury's common knowledge. It offered assistance to the jury in determining whether the defendant was able to form the intent, and it did not amount to an opinion, this is the part I want to emphasize, that the defendant or any other 15-year-old was incapable of forming the intent required for murder. Aren't you making that very argument that that's why he should be allowed to testify here?
No, I was never making an argument that he would need to evaluate Joshua in order to testify. I'm making the argument that if the Commonwealth is going to put a 16-year-old on trial and say that the 16-year-old can form a specific intent to kill, and that he wouldn't be affected by the facts of this case. The facts of this case is that there was a codefendant who was 20, who, according to the Commonwealth, was the ringleader, was putting pressure on Joshua, and in some ways intimidating Joshua into becoming involved, and that there was issues regarding impulsivity. And so the facts of this case are very different than the facts of Okoro. And we at the Commonwealth argued that these specific issues that would result in Mr. Fernandes spending the rest of his life in jail, unless the jury were educated as to why. Why would a 16-year-old participate in this manner? And we're suggesting that had they had the information from the expert in this case, that it would have made a difference, we believe, in terms of culpability. It would have made a difference to explain the impulsivity. It would have made a difference to explain the peer pressure. And the jury never got to hear that information.
But we're in Okoro, we say we can't just allow you to sort of testify generally. We need some specific knowledge about this particular defendant, not just the facts of the defendant's case, but you need to have the expert needs to be familiar with this particular defendant. Isn't that what we're saying in Okoro?
Oh.
And that's exactly why the judge didn't allow that here.
No, I don't think that that's why the judge didn't allow it here. I think what the judge said here with respect to this case is that, well, at least according to the Commonwealth, that there was some claim that they didn't understand the proffer of what Mr. Kenshaw would testify to. And that's simply just a fallacy. We brought up the juvenile brain in the motion to dismiss, and the motion to suppress, and the motion in limine, and the required finding, and the request for jury instructions, and the request to have Dr. Kenshaw testify at sentencing. So we're a little bit different, and I think that distinguishes us somewhat from what happened as far as Okoro is concerned. But the idea that an expert can't educate a jury on a new and developing area of the law, I would suggest is exactly what this court has asked us to develop in both Robinson and Mattis. We're not talking in either of those cases about expert testimony as to the defendant. We're talking about what is the science? Tell us what the science is behind this. And that's what we were looking to educate the jury of, is what is the science of this impulsivity? What is the science of this susceptibility to peer pressure, especially on facts like facts that were here, where there was clear evidence there was peer pressure. There was clear evidence that there was impulsivity. And we allege that the jury had the right to know that, and not to determine whether to believe the expert or not, but to determine whether or not that knowledge would have made a difference in their decision. And our suggestion is that it would. And if you don't have any further questions on that issue, I'd like to move on to the statement and the denial of the motion to suppress in this case, which resulted in Joshua's statement being introduced at trial, which resulted in an implication of guilt by the Commonwealth through their closing argument. Now, the statement in this case was 16-year-old Joshua was arrested. He was taken to the police station. His parents were called. His father showed up. There was some discrepancy as to whether or not his father could speak English. Ultimately, what happened in this case is that they got an interpreter who was another police officer who came and spoke to the defendant in this case. And then the question was asked, did he want to speak to them? And he said, I'm all set. And then the police officer went on and said, so do you want to sign this form that waives your rights? And he says, no. Now, we're intending that that was not ambiguous. It was an invocation of his Fifth Amendment right to remain silent. And it was not scrupulously honored by the police. And if there was any ambiguity at all in the statement, I'm all set, when he asked if he wanted to speak, and the subsequent statement of, no, I don't want to sign the Miranda waiver, then it was incumbent upon the police officers, not a 16-year-old boy, to ferret out any ambiguities in that, to make sure they understood that he was forcefully exercising his Fifth Amendment right to remain silent in this.
Can you remind me of the timing? So I'm all set and the refusal to sign, then he goes to speak to his father, or I can't remember the timing.
He has spoken to his father before that. So he's spoken to his father, and they come back into the room. The allegation, at least in the findings by the motion judge, is that the father waves the police back in the room. They ask him whether or not he's willing to speak to them. He says, I'm all set. They ask him whether or not he wants to sign the Miranda waiver, and he says no. Now, the Commonwealth is taking the position. I'm sorry, Your Honor.
And then what happens? And then what happens next? He doesn't.
He says no, and then instead of scrupulously honoring his request to remain silent, the police then say, I just want to tell you that we have witnesses who put you at the scene, who say that you did this, that, or the other thing. And he says, at first, nothing happened. And when he says nothing happened, the conversation continues. But that conversation about, what happened and what they had should never have even taken place. He had invoked his Fifth Amendment right to remain silent. And in that case, should have been honored. And the suggestion here that it wasn't honored, and that somehow the Commonwealth now wants to say that his invocation of no, I don't want to sign the Miranda waiver, is somehow separate and distinct from his I'm all set statement, to make them two separate issues, which the Commonwealth says were ambiguous. then even if it was ambiguous, the onus was on the police department to clear up any ambiguity, and they did nothing to clear up the ambiguity. Instead, they made statements that this would be Joshua's only chance to tell his side of the story. That's what they said. And that information is contained directly in my brief. And I would suggest that because they didn't scrupulously honor Joshua's request to remain silent, that there's a problem. But there's another problem with the statement as well. The interpreter that came to interpret, who was not a court certified interpreter, but instead was an interpreter who in this case, wasn't interpreting everything correctly. And so we hired an interpreter for the motion to suppress hearing, a certified court interpreter who interpreted what was actually being said. And some of the most key points of the Miranda waiver were not read to the father. For instance, when they were told that he had a right to have an attorney present during the statement, that wasn't translated properly. And it came out as he had a right to have an attorney present, but not any indication that he had it during the statement. So even if there was an interested adult, even if you want to look at this to determine whether or not it was voluntary, I think you have to look at the pressure that the police put on him, the now or never language that they use, combined with the fact that the interested adult wasn't properly advised of his rights. And even Detective McDonald said, had he known that the transcription or the translation was wrong, he would have stopped everything to make sure the translation was right. But nobody understood it because they didn't use a certified interpreter. They used whoever happened to be in the police station at the time who could speak Cape Verdean.
A couple of things. I just went back and read. On your first point, they go back to the father and the son go back into the room after the ambiguity about, I'm all set and refusal to sign. Then they come back and the police officers ask them again, so do you want to talk to us, right?
Yes.
So there is a subsequent, if there's ambiguity about what's going on, isn't it clarified afterwards when they come back?
How is it clarified by him saying, I'm all set and no, refusing to sign the Miranda waiver, and then having this conversation? The mere fact that he was speaking to his father, who wasn't appropriately advised of his rights, who didn't even know that he could have a lawyer present during the statement. How can you say at that point that he validly waived his Fifth Amendment right to remain silent? I don't think you can on this evidence.
Let me go through that factually with you for a second, because I was concerned about what the translation. So I've gone back and forth, and tell me where I'm wrong. So the first Miranda right, you have the right to remain silent. From what I understand, the translation to that was you have the right to remain silent. That was correct, right?
Yes.
Second one, anything you say can and will be used against you in a court of law. The quote translation, anything he says, they can use it against him in court. No problem with that one, right?
No.
Third one, you have the right to an attorney. Okay, here's where it gets a little confusing. Have the right to an attorney before he answers any question. Then Mr. Fernandes steps in and he's somewhat confused, right? And then the follow-up translation is as follows. No, you have the right that if they start, if you want, you can be silent, and they are reading your right as long as you understand all your right. But after that, just like I told you, if anything they ask you, if you remain silent, you have that right. Okay, that's your focal point, right?
Right.
On that one,
because that doesn't suggest that he had a right to have an attorney present during the questioning, and that's what Miranda requires. And that's not
the first part of it says that you have the right to an attorney before he answers any question. The first part's correct. It's when Mr. Fernandes gets confused, there's this garbled thing, right?
Right. But the right to an attorney and the right to have an attorney present during questioning are two separate things. And that's the part that doesn't get transcribed. The part that says you have a right to an attorney to be present during questioning. So even if you have a right to an attorney in this case, then you also have to have an understanding that you have a right for an attorney to be present before you make any additional statements. And that's the part that never got transcribed. That's the part that doesn't get communicated.
Because there's an end. If you just, so the right is if you decide to answer questions now without a lawyer present, you have the right to stop answering it at any time, right? That's the warning.
Yes,
The translation, if he decides right now to answer any question before the attorney is here, he can stop at any time he wants. He says that, right?
yes,
And if you decide to answer any question before you have an attorney here, even if you start, you can stop any time that you want, right?
that's correct.
Okay, so I just want to make sure we pin down factual points.
Right. The factual point is that they never told Mr. Fernandes or Joshua that he could have an attorney present during questioning. That's part of the Miranda. It wasn't communicated. There was clearly some confusion. There was no effort to straighten out the confusion. And in all sense, if they had a certified interpreter taking these statements, this wouldn't have been an issue. But this just happened to be a police officer who believed he spoke Creole and was doing this translation. So they didn't even understand exactly what was happening. And even at one point, Mr. Fernandes says, well, you just said to remain silent. And so he's clearly not comprehending the words that are coming out of the translator's mouth. And there should have been some inquiry as to whether or not he truly was an interested adult if he did not have the capacity to understand, comprehend, and advise. And that's what we're suggesting was wrong with the statement. And then in terms of the final argument, which was my closing argument, the argument, I know the court has addressed it in Lopes, and I know this court understands what happened in Lopes, but the court also made a statement in Lopes that the reason that it didn't really affect Lopes is because the argument, the third party culprit argument, really went to Fernandes, not Lopes. It was Fernandes' argument that they were calling an insult. It was Fernandes' argument that they were calling a farce. It was Fernandes' argument that they were calling a distraction in this case. And there was no limited instruction to the extent that, it's not a farce. This is, advocacy. This is what a lawyer is required to do. Instead, the court said, don't get too carried away with the closing argument. That's not a limiting instruction, especially when it goes to the heart of Joshua's defense. So despite the fact that the court took up this issue with Mr. Lopes, it did not consider it with respect to the third party culprit argument that I raised. And there was no limiting instruction. There was no cure. And we don't know how the jury relied on these, the insult, farce, and distraction, because they weren't told to ignore them. Instead, they were told not to get too carried away. And I haven't found a single case that says when a judge tells a jury not to get too carried away, that's a sufficient curative instruction for an egregious error in closing argument. So I think that also should result in the reversal of Joshua's conviction. And I'm not sure, Your Honors, if anyone else on the bench had questions. I can only see one person on my screen, so I'm not sure if anyone else had questions about anything.
No, we're all here and we got it. We think that Justice Kafker covered.
They're not shy, don't worry. They speak up.
Well, if there are no further questions, then I see my time is up, and I would rest on my brief. And I'd ask that you consider reversing 16-year-old Joshua's conviction for first-degree murder based on the fact that the jury selection violated his rights, based on the fact that he was denied the opportunity to hire an expert, and based on the fact that his statement should not have been introduced against him. And I'd ask the court to look at the closing argument and the way that the prosecutor used the closing argument against Joshua when he said these words, which is, what is a lie? The lie is the last refuge of a guilty man. That's what he told the jury. That's how he used Joshua's statement against him. And that's why he should get a new trial.
Thank you very much, Counselor.
Thank you.
Okay. Ms. Campbell.
Good afternoon, and may it please the court, Cailin Campbell on behalf of the Commonwealth. Before I start, I would like to acknowledge the victim, Nicholas Fomby Davis, and his family who are watching. We ask you today to affirm the conviction of the defendant for the murder of 14-year-old Nicholas Fomby Davy, who was executed while simply riding a scooter in his neighborhood 2 blocks from his family home. I'll start with the Batson issue, and I think there's a factual clarification that should be addressed first. The first is, this can be found on volume 4, pages 41 through 42. A young Black female college student, she was a junior, was sat on the jury. The the Commonwealth had run out of peremptory challenges by then, and this juror was sat. So I don't think it's fair to say that this jury did not have any individuals who were not young on the jury. Not that that is dispositive of the issue, but I think it does speak to the cross-section argument that my sister makes. I'll largely rely on my brief and the analysis in Lopes, but I didn't understand my sister's argument to be a due process attack on this. Even if it were, it falls into a similar analysis as if it was an equal protection claim, because where a non-suspect class is challenging something, it would just need to be a rational basis test. And certainly looking at the prosecutor's justification as to why he wished to strike these jurors had a rational relation. The judge found that it was justified and it was content neutral. So it was satisfied that test as well. As to my sister's argument that it is sort of superseding the role of the legislature to say that young people can't sit on juries, it is also statutorily created that both the defense and prosecutor can use peremptory challenges to challenge jurors so long as they are not used inappropriately. So I'd say that there are sort of two statutes that need to be addressed on that ground. Moving to my sister's argument about the expert, I disagree that this is at all like the Robinson and Mattis cases, which she mentioned in her argument. In both those cases, the question is whether Diachenko and his progeny should be expanded to include individuals who are over the age of 18. And that is certainly not the issue that is here. As I think I addressed in my brief, this is on all fours with Okoro. And it struck me as I was listening to my sister's argument that she was talking about the defendant in this case specifically. And she was saying that he had specific characteristics which could have mitigated his intent. And had an expert analyzed him and offered or even proffered a report as to that, then I think we would have a very different.
That can't be right. Well, it's been a while, but I've seen lots of murder cases and participated in many murder cases where a defense expert says, I never examined the defendant, but let me tell you about cocaine addiction. I never examined the defendant, but let me tell you what DTs mean or alcohol. We've never said that an expert can't testify on diminished capacity type issues unless they've examined the defendant and can proffer an opinion about the particular defendant. This seems like we're changing the rules in this type of diminished capacity. That doesn't seem right to me.
Well, I would disagree with you insofar as I think Okoro and Brown can be read to hold that where it is adolescent brain development, that there is required to have some sort of evidence particularized to this defendant. And I think it's different than, let's say, cocaine addiction, as mentioned by Your Honor. My understanding of juvenile brain development and the limited proffer that was given here is that it varies from individual to individual. So while there are some individual truths, it would be hard to just generalize.
It may be that Brown and Okoro are wrong then, because you're still talking about, cocaine addiction is individual to person, and lots of experts I've seen in court come up and say, this is what happens when people are addicted to cocaine. I don't get why we should distinguish and make it harder for people to raise this claim than we have for other types of diminished capacity.
Certainly, I think it gets back to what the precise question is in this case, though, which is whether Judge Brady abused his discretion.
And then I was going to get to that as to what happened here below that caused Judge Brady to say there wasn't enough discovery, there wasn't something to exclude in such that it was an abuse of discretion.
Correct. And I think if you look at the chronology of how this was brought up, it was first ever mentioned to the Commonwealth 3 days before the trial was slated to begin. The proffer that was given on the record, it was raised through a motion to dismiss, which was simply that Dr. Kinshirf would offer evidence generally about adolescent brain development. Judge Brady notes himself during the jury charge that there really wasn't any ever proffer as to the contours of the testimony that Dr. Kinshirf would give. So it simply wasn't developed enough, I think, to say that Judge Brady abused his discretion on the basis of what was presented to him. I also think based on the basis of what was presented to him, it's different than sort of an expert who would opine, you know, using the cocaine analogy again, sort of this is the effect, this is what you could expect to see, because it amounted nothing more to someone by status of their age couldn't form the requisite intent. It was simply he was 16 years old and he's going to testify as to why he couldn't form the intent because he was 16 years old. I think that distinguishes it from the hypothetical posed by Your Honor. And I think the same, if you look at the reasoning in Brown and its interpretation of Okoro, it follows that same reasoning that I just said here, that you really do need more than a simple generalization.
Well, if you have a diminished capacity issue, for instance, by way of alcohol, there may not be an interview of the defendant, but that specific circumstances in the case with an argument as to how that specific circumstance applies to a defense, capacity to formulate the intent.
Correct.
Whereas this would be a general statement without any other facts to call an opinion from.
Correct. And I don't think that, though there are some generalities of you know, how it's recognized in the law, obviously, that juveniles' brains are different than adult brains. I think specificity is needed such to explain why this defendant, specifically my sister mentioned susceptibility to peer pressure and impulsivity. Certainly an expert could interview the defendant and speak more better and have evidence as to that, which could be used by the jury. And I've seen it used by the jury where they're then said, okay, you're to consider the evidence of this defendant's specific mental condition and how that affected his ability to form an
Could it be
intent.
the circumstances though? Could it be, obviously there's not a defense of duress in a murder case, but could there be the circumstances that might speak to capacity to formulate the necessary intent?
I don't want to rule out that there never could be, but I also would caution just like an intoxication defense, for example, you're not necessarily granted it if there's only testimony that you had a drink, for example, right? There has to be some level of incapacitation.
Yeah, but here the qualifier is you're a juvenile. So not every defendant is going to be able to say they were intoxicated, but every juvenile can say they were juvenile.
They can, that's true. But I think that there needs to be, and again, tying it back to Judge Brady and his discretion at that point, certainly it would be a change to say that age standing alone would warrant this type of treatment, right? Because both Okoro and Brown specifically state that age standing alone doesn't give rise to sort of.
This is well before Okoro and Brown were decided, wasn't it?
It is. This is in 2012.
Right.
So it's well before. And as I argue,
So that cuts both ways though, right? Because this whole idea of the special treatment for juveniles at this stage is very undeveloped, right? The knowledge about the juvenile brain is, what year are we in this case when this is tried?
2012, so it's pre-Diachenko even.
So this is pre-Diachenko, pre-Brown, pre-Okoro. Is Judge Brady not sort of doing this at that point in time, an abuse of discretion?
Correct. And I'd say you have to look at the development, especially in areas like this, as it existed at the time the judge made his decision. And certainly it's a very different landscape now than it was then.
Although your sister is pushing to change that, even at this time, your sister is prescient. She's pushing for this type of stuff, which we get into.
Absolutely. And though, I mean, I'd say that she did raise it at the trial below, which is something that many attorneys may not have done, not pushing and being prescient, such as Attorney Scapicchio is. That doesn't change sort of the analysis of whether Judge Brady abused his discretion, though. And I'd say on this fact, on this proffer, on this record, the answer to that is no.
Could you
Moving to.
and I don't mean to cut anyone off, but I would like you to go through carefully the motion to suppress and the statements, particularly sort of how we deal with that really sort of garbled instruction that I went over with Ms. Scapicchio.
Sure. And I think it's important to look at Judge Brady's factual findings here, which aren't challenged as clearly erroneous by my sister on appeal, and his reasoning as to why. I'll start with the sort of translation of the Miranda warning. Though the part highlighted by my sister is not sort of a verbatim accurate translation, Judge Brady found the later part where he talks about having a lawyer present, and if you decide to answer, I think specifically, and this is on page 21 of my brief, it's located on addendum pages 80 to 86 of the Commonwealth's brief. You have to look at the chronology of how this was translated, specifically that Officer Texera told the defendant's father, if you don't have money for an attorney, they'll give you an attorney for free. The very next morning, the way that it's translated is, if you decide to answer any question now without a lawyer present, you still have the right to stop answering anytime you talk until you talk to a lawyer, if you understand that just initial right there. If you decide to answer any of the questions before you have an attorney here with, like, you can even start or stop anytime you want. So I think there is an acknowledgement when you read it in conjunction that you have a right to an attorney. They will give it for free. And if you decide to answer questions without the attorney here, you can stop at any time you want. I don't think I think that's sufficient to cover the basis of Miranda. I also disagree with my sister where she, in her argument, claimed that the defendant himself was given an improper Miranda warning. That's certainly not borne out by the recording or the findings of the judge. As to the specific factual chronology of the alleged invocation of the right to remain silent, again, I urge the court to look at Judge Brady's findings, which aren't challenged, but specifically, they get to the end of the Miranda forum. Detective McLaughlin then said, and I'm quoting from Judge Brady's findings, okay, so if you understand all those things and you're willing to speak to us without a lawyer present, you just have to sign right here, and then the officer will witness it. The defendant responded, I'm all set. Detective McLaughlin then said, you don't want to sign it? And the defendant said no. That happened before he consulted with his parents. If you look.
So what are we supposed to make of no there? No means yes, yet no means no. I'm not sure what it means.
So here, I think at best it's ambiguous, but here's where the chronology is important. If you look at what happens next, Mr. Fernandes then asked to speak to his son. It's at that point that the recording is paused. The defendant goes and speaks to his parents for 10 minutes, and then they wave the detectives back in. So I'd say the waving of the detectives back in is evidence that it wasn't an unambiguous invocation of right to silence. But even more than that, when they get back in the interview room after they're waved back in, Detective McLaughlin again asks clarifying questions. We're just seeing if you want to talk to us, you don't want to talk to us, you don't want to tell us what happened. And it's at that point that the defendant begins to.
But didn't they have an obligation at the no, I'm all set to just do nothing? You just stop and say it's a declination.
I don't believe so, because I believe the case law says if it's unambiguous, which I think given that they were.
Oh, what about no, I'm all set? If I say to you, would you like a hamburger? And you say, no, I'm all set.
No, but if you say to me sort of a conjunction of two things, right, which is what happened here, you have to sign right here. Okay, do you want a hamburger? Do you want to sign right here? And I say, no, I'm all set. I think that the case law says you can ask a clarifying question.
So the all set was in your mind, in Judge Brady's mind, apparently was, will you sign this?
And Detective McLaughlin does the same thing. He says, you mean you don't want to sign this? And he says, yes.
Okay, so he says, I don't want to sign this.
He says, I don't want to sign this. And he says, no. He says, I don't want to sign it.
And then what happened?
And then the father says, I haven't really gotten a chance. That's when the father puts the brakes on.
Before you move that, what if he doesn't want to sign it, but what does that mean? How significant is that? I take it you're interpreting, or Judge Brady interpreted that to mean he was willing to talk, but he didn't want to sign?
Well, So I think what the detectives did here is, and what the case law says you can do when you don't really know how to respond to a response that you get, is to ask clarifying questions. Here, what happens is, that happens, then the father, it's at that point, almost that exact point, that the father says in English, like, I don't know what happened, and he asked to go speak with his son. So there's a pause in the proceedings. After that, I'm all set. And I think that pause is important, right? And I think it's important, as Judge Brady found, that it's the defendant and his family that waved the detectives back
So
in.
we have to agree with your position, Judge Brady, that there was an ambiguity during that I'm all set part for it to proceed, correct?
Yes.
Okay.
Yes. But either way, it gets interesting, right? Because yes, I think that's sort of the yes, but you could invoke and then invite back in. So certainly at the point that
If he initiates.
If he initiates, I'd say here it's, but then the waving back in, that gets interesting. I think even then there's sort of clarifying questions. It doesn't launch into, so, Joshua, tell us what happened, right? It's more like, okay, you don't want to talk to us, you don't want to talk to us, and then he starts talking. So certainly, I think the most reasonable way, and I think certainly supported the way that Judge Brady both found the facts and reasoned, is that this was ambiguity, that there was a pause, that they do call him back in, and that then the defendant decides to respond to the officer's questions.
How significant is his statement at trial?
Not very significant. It's interesting because it gives the defendant an avenue of defense that he wouldn't otherwise have if it wasn't admitted, in that he, when he speaks to the police, he exculpates himself. He puts himself there, but I mean, that's proved by
How does the Commonwealth use his statement in closing? I can't remember.
The prosecutor played that part of the statement where he gave his version and then used it to say, look, he is making up this story, which is evidence of his guilt, right? It doesn't give the Commonwealth sort of, if you were looking at it in terms of, does it fulfill any element of the crime that the Commonwealth otherwise didn't have? The answer to that is no. And it has to be looked at in light of the overwhelming evidence of
There's strong identification evidence here.
I'm sorry, can you?
There's strong identification evidence in this case.
Absolutely. There's surveillance video and two eyewitnesses who watched the entire murder unfold. I
can't remember the surveillance video. How clear is the surveillance video?
The surveillance video, it's not the clearest. It's from some distance away, but it certainly supports, the observations that were made. The better evidence and the best evidence is really Officer Williams and Mr. Singletary, who are feet away, who watched the entire thing.
Ms. Campbell, before you go to the closing argument issue on the constitutional challenge to the statute,
Yes.
is there any reason why Commonwealth versus Freeman isn't dispositive of that issue and rational basis?
I'm sorry, I didn't hear.
Commonwealth versus Freeman?
Freeman? Yes,
yeah.
I believe it is dispositive. Your Honor. And I'll move to the closing argument issue. I disagree with my sister's reading of Lopes. It was called an overly aggressive argument by this court 3 years ago in Lopes. I think it's a fair reading that it was overly aggressive, but if you look at really what it was a response to was in large part the argument made by Attorney Scapicchio in her closing argument. There was that curative instruction that was given, which this court in Lopes held was sufficient to cure it, but it also has to be looked at in light of how it was in conjunction with the closing argument as a whole. And certainly the attacks on Ms. Scapicchio were not the focus of the closing argument as a whole. It has to be looked at in light of the overwhelming evidence of the defendant's guilt and the other jury instructions that Judge Brady gave, which included that closing arguments were not evidence, which the jury is presumed to have followed. If there are no further questions, the Commonwealth will rest on the remainder of its brief, but it urges this court not to reduce the verdict under 33E. This was an execution of a 14-year-old on a beautiful May night while he was doing nothing but simply enjoying his life on the street. And it absolutely supports the verdicts of first-degree murder in this case.
Okay, thank you, counsel.
Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within the Commonwealth. At President Hart, and this court is now adjourned. God save the Commonwealth of Massachusetts.